That's right.
Okay, good morning everybody. It's 10 o'clock and time for me to open this inquiry. Can everyone in the room see me and hear me okay? Yep, you're a long way down there at the back of the room, so if you can't hear me at all, then please do bring it to my attention and we'll see what we can do. Can I also check that the live stream is working and that those on the live stream can see and hear me? Yep, good. Thank you very much. My name's Patrick Hanna. I'm a Chartered Town Planner. I'm the inspector appointed by the Secretary of State to hold this inquiry into two linked appeals. Both appeals are made by Taylor Wimpey and Homes England against the decisions of South Ribble Borough Council to refuse, firstly, an outline planning application with all matters reserved except for the principal means of access for a residential-led mixed-use development of up to 920 dwellings, use classes C3 and C2, a local centre including retail, employment and community uses, use classes E and sui generis, a two-form entry primary school, use class F, green infrastructure and associated infrastructure following the demolition of certain existing buildings. And secondly, an outline application with all matters reserved except for the principal means of access for a residential development of up to 180 dwellings, use classes C3 and C2, green infrastructure and associated infrastructure. Both of these appeals have been recovered by the Secretary of State, and that means that instead of these appeals being decided by myself, the Secretary of State has directed that I shall instead prepare a report and recommendation which will be forwarded to the Secretary of State for his own determination. For the benefit of interested parties, this makes these appeals rather special in that the Planning Inspectorate deals with some 17,000 appeals a year, yet in 2021 only about 17 recovered appeals were determined by the Secretary of State. The reason given by the Secretary of State is that the appeals involve proposals for residential development of over 150 units or on sites of over 5 hectares, which would significantly impact on the government's objective to secure a better balance between housing demand and supply and create high quality, sustainable, mixed and inclusive communities. Right, just some housekeeping matters to start, please. Could everyone please ensure that their mobile phones are switched off or set to silent? The same with any audible notifications on your computers and smartwatches as well, it seems these days. As I understand it, there's no fire alarm today. So if it does sound, then it's genuine and we need to head back out the way we came in using the stairs. The housekeeping note that I'm sure everyone has seen coming in also says that you shouldn't leave the room unless accompanied by a member of staff, and when you're coming back in again to speak to reception, who will come and collect you. Right, some introductions. Firstly, for the appellant, we have Mr. Katkowski. Please correct me if I've mispronounced that. Could you introduce yourself to the inquiry, please? Indicate who instructs you and introduce your team, please.
I would indeed. So I've got a little list. I had a little list. That's my morning exercise.
Thank you very much.
You've already got these. Thank you, sir. So yes, you have pronounced my surname correctly, for which many thanks. I'm Christopher Katkowski, Queen's Counsel. I appear together with Miss Bell, who's sitting to my right of counsel. We're instructed by Avison Young, and so in due course we'll be calling the following witnesses. We have Mr. Stoling on air quality, or having a round table session on air quality matters. And then in the right order, we will be calling Mr. Adam Thornton on master planning issues, Mr. Mike Axon on transport, and finally Craig Alsbury, Mr. Alsbury on planning. And so when you get to the Section 106 session in due course, then Mr. Lloyd, who's sitting behind me, Richard Lloyd, who's a solicitor, will be assisting with that. That's who we are. Thank you, sir.
Thank you very much. And for the council, Mr. Ponter.
Morning, sir. Hopefully you've got a list of our appearances on your desk. My name is Ian Ponter. I'm a barrister instructed by Tasneem Safdar, who sits to my left, who's a member of the legal team at the council. And likewise, 4 witnesses, Sir Dr. Darren Price, Mr. Murray Lloyd, Mr. Neil Stevens and Mr. Richard Wood. And that's the order, I think, in which they're likely to appear according to the current timetable.
Okay, thank you very much. Good. I've also been advised of 2 interested parties wishing to speak to the inquiry this morning. Is Councillor Walton here today? Okay, thank you very much. And I understand you're a ward councillor, is that correct? Okay. And are you objecting to the proposal or supporting the proposal?
Issues that I would like to raise about the proposal.
Sure, yep, that's fine. Later on I'll invite you up to make your statement. Will you be happy answering questions on? Yes, okay, good, thank you very much. And I've also been advised that Mr. Eastman and Mr. Bow, both representing, hello there, both representing the Keep Bee Lane Rural Group, objecting to the proposal, and you're both intending to speak, is that correct?
Correct.
Okay, thank you. And if you're both speaking, could you please try and ensure that you don't repeat any material? That'd be appreciated. I don't need to hear any evidence twice. And it's not an effective use of inquiry time. Are you both happy to answer questions on your statements? Yes, thank you. Is there anyone else in the room that wishes to speak to the inquiry regarding either of the appeals? Nope, no one at the moment. Okay, thank you. There should be an attendance list circulating. Could everyone please ensure that they've added their name and contact details to that? It's primarily in the case of something happening to the event and we need to get in touch with you to let you know that it's back on again. Is anyone from the press present today? Nope. Okay. And last thing about the attendance list, could the council please try and return them to me at the end of the day, please? Thank you.
Noted. Thank you, sir.
Thank you.
Taz, can you be in charge of that?
Right, as I mentioned earlier, the inquiry is being live streamed on YouTube. Does anyone else intend to film or record the event?
No, sir.
No? Okay. And anyone have any objections to the live streaming? I noticed that interested parties are not shown on the screen. Everyone happy? Good. Right, I've already received a copy of the council's letters of notification and a list of those to whom the notification has been sent in respect of both the appeals and the confirmation of the date and time and location of the inquiry. Is everybody content that the notification requirements have been met?
Yes, sir. Thank you very much.
Thank you.
Thank you, sir.
Thank you.
Sure they have, yeah. Thank you.
I have copies of the representations made in response to the original planning applications and to the appeals. Some 9 representations were made directly to the inspectorate in response to the appeals. The appellants should have seen all of those letters of representations, and they're all consolidated into a single core document, as I understand
Thank you,
it.
sir.
Yep. Okay, thank you. Please be assured that all written representations will be taken into account when I am writing my report. Primarily for the benefit of interested parties and in the interests of openness, I previously held a case management conference call in June with representatives of both the appellant and the council. It was held to discuss the procedure for the inquiry, and the conference call covered the following matters: where and how the inquiry would be held, what the likely main issues would be, how the main issues would be dealt with, the running order of the inquiry, and the management and submission of inquiry documents. And for the avoidance of any doubt, the merits of the appeals were not discussed. I shall follow the procedure in the Town and Country Planning Inquiries Procedure, England Rules 2000 as amended, which applies to appeals that are recovered by the Secretary of State. When I've concluded my introductory remarks, I'll invite the appellants to make a brief opening statement, followed by the council, and this will help everyone to understand the main arguments. I will then hear from interested parties that wish to speak, and the opposing advocates will normally be allowed to ask questions of each speaker. I may also have questions. If you're reading from a statement, then it would be very helpful if a copy of that could be provided to me in order to most accurately convey your representations to the Secretary of State. Perhaps you're able to pass a copy of it to the council, who should be able to copy it for the main parties. We can deal with that as each of you come up. The evidence will then be heard by way of formal presentation of evidence and cross-examination. The council's evidence will be heard first. The council's first witness will present their case and objections to the proposal through examination in chief by the council's advocate. The appellant's advocate will then have the opportunity to cross-examine the witnesses. I may also have some questions. The council's advocate may then put some questions in re-examination. Each of the council's witnesses will be heard in the same manner. At a suitable point in proceedings, I'll hold a round table session about air quality matters, and this will consist of a structured discussion that I shall lead. Based on the information before me, it will be brief, as I'm simply seeking some clarification as to why the dispute over traffic data inputs are relevant when many of the other matters have been agreed, but we'll come to that in due course. After hearing all of the council's case, the appellant's witnesses will be heard in the same manner, that is, case evidence, cross-examination by opposing party, opportunity for any questions from objectors, questions from myself, and any re-examination by the appellant. There are two tables spare today. This is for the witnesses. For third parties, if you just simply want to come to the front of the seating, that would be good. When all of the main considerations have been dealt with, I will hold a discussion on conditions and planning obligations. This is standard procedure. It does not indicate that I've made my mind up on the proposals, nor does it weaken the council's continued opposition to the proposal. Once the agreed conditions and obligations have been submitted to me, and I'll come back to that later, I will then circulate some initial comments which should help to make that session as efficient as possible. I will then hear closing submissions from each party, first from the council and then the final word to the appellant. These must be provided in writing, and it is my intention to use those closing submissions as the basis of my summary of each party's case in my report to the Secretary of State. I'm not inviting any applications for costs, but if anyone intends to make an application, this must of course be done here before I close the inquiry. Are there any intimations of that at this stage?
To be advised, sir, I think.
Okay, thank you.
No, sir.
Thank you. In addition, I also have a power to initiate an award of costs, whether or not any applications have been made by the parties, and if I were to do this, it would follow a written process with the relevant party after the appeal decision is issued. I've already visited the site and I'm familiar with it and its surroundings. Yesterday I drove around the lanes within the sites. I drove over both Bee Lane Bridge and Flag Lane Bridge in both directions and all of the main streets surrounding the site. I also drove around all 7 of the junctions identified by the council as being particularly sensitive to intensified use. I will be making another site visit at a relevant point. At the case management conference, it was agreed that this is likely to be an unaccompanied site visit, i.e. I don't need to be accompanied by both parties and by interested parties. So if there are any particular suggestions of places or features that I should visit, then please bring those to my attention as the evidence progresses, and I'll keep a note so that I can go and visit those particular places. Any comments on the running order?
No, sir.
Thank you. The inquiry is scheduled for 16 days. That's 4 weeks with Mondays as non-sitting days. The very helpful time estimates from the advocates, which are tabled at the back of the agenda, suggest we should finish sooner and within 3 weeks. Let's keep our fingers crossed. I will break for lunch around 1 o'clock each day, with short breaks in the morning and the afternoon. And I will seek the assistance of the advocates in finding suitable times for breaks. I shall aim to finish each day at around 5 o'clock, and on the 6th of September I've been advised that will be a firm time limit, as no streaming will be available on that day.
The 6th of September, sir? Sorry.
That's correct,
what
yes.
Was a firm time limit? 5?
5 o'clock.
Thank you, sir.
We will start at 9:30 each morning, but there are a few exceptions to that. The building doesn't open until 10 o'clock on Wednesdays, and so tomorrow, as the agenda is fairly light, I suggest we meet at 10:30. That will give us time to get in and set up.
This is my kind of inquiry. I'm loving this. 10:30.
However, the following Wednesday, the agenda is clearly a lot fuller, so I will be asking the council on that day to allow everyone that is attending to come into the building for 9 o'clock, so that we can start for 9:30.
Okay. Thank you, sir.
Is that acceptable?
No, we'll ensure arrangements are in place.
Thank you very much.
You're going to be opening up, are you, Ian? For the
Yes, I'll be with my high vis down in the front.
Right, the other exception is Tuesday the 30th of August, when we will resume after lunch at 1 o'clock to accommodate the preceding bank holiday Monday. The plans that were before the council for both appeals have been agreed by the appellant as being those listed in condition 2 for each appeal, or proposed condition 2. So everyone should be satisfied that we're looking at the same plans. Yeah, everyone happy with that? Yeah.
Indeed, sir.
Good. No updated plans proposed, I'm assuming?
No, sir, not today.
Good.
No updated plans proposed.
Good.
Sir.
Thank you very much.
I say that when I don't know whether it was copied to the planning. Yes, it was copied to the planning inspectorate. Yesterday, you might have received an email. Your case officer might have received an email clarifying the council's position on building heights.
Okay.
And I'm yet
right.
to take instructions on our position vis-a-vis that. Depending on what our position is, that might or might not mean that we have to adjust one of the parameter plans, but we'll see. So if I can just mention that to you, so it may very well be that we don't do anything at all in response to it, but I just need time to check.
So there was a short email sent to both the appellants and the inspectorate from the council in respect of the issue of building heights. It's referred to in the main statement of common ground. For your reference, that's paragraph 6.3 of the main statement of common ground. And in light of my witness's evidence on master planning, the council proposes to amend its position in respect of building heights. The short email sent yesterday explains what that modified position is. Obviously, the friend's got to take instructions from his clients as to that, and hopefully it's helpful. It might inform the debate later on today with the evidence given by Dr. Price. He can explain his position.
Okay, thank you very much. In terms of the other documents, all documents are available for all parties to view on a dedicated website, and thank you to the Council for that. That's very helpful. Please do add any and all new documents that are received during the inquiry to that, and if anything is added, then again do let me know. And thanks also for fixing the colour contrast on the website. It was particularly difficult to read as it was previously, but that's good now. Right, in terms of the proofs, from the Council I have for Mr Wood, dealing with planning matters, a proof of evidence and a summary proof. From Dr Price, dealing with design, I have a proof and appendices and a summary proof. Mr Lloyd on viability, proof and appendices and a summary proof. Mr Stevens on highways, a proof and appendices, a summary proof and a rebuttal.
Indeed.
And Mr Martin is a proof and appendix, which is a statement of common ground on air quality. Good. From the appellant, I've received from Mr Alsbury. I'm afraid Mr Alsbury is rather hidden behind my screen there. I hope that's not too disconcerting. On planning, a proof of evidence and appendices and summary proof. Yep. Mr Thornton on master planning, a proof and summary. Mr Axon, transport and mobility, proof and appendices, summary proof, rebuttal and appendices.
Sure.
And from Mr Stoling on air quality, a technical report.
Yes, which,
yeah,
thank you.
Okay, I have read all of these documents, and so I would expect them to be largely taken as read. However, I have not read every inquiry document, so please do highlight matters that you consider important to your case. There are a number of documents still outstanding. First of all, the highways statement of common ground. Slightly concerned that proofs and rebuttals have been provided without agreeing that, but you got an update on that, please?
I will have in one. I just want to double check. Did we respond yesterday? Yeah. Okay. So without a sort of, who did what, when, etc., etc., etc. Basically, at the moment, we've received a draft. A draft has been exchanged backwards and forwards between the council and ourselves. We've responded to the latest iteration of that as of yesterday afternoon. It might have been quite late afternoon, so not that I'm making a point, but at the moment it's with the council. But it's in hand. So
okay,
I think the parties are trying their best, if you like.
Okay.
Yes. So comments on the latest draft from Lancashire County Council as the local highway authority, really driving this. Comments received back from Mr Axon very kindly, I think 5 o'clock-ish yesterday. Mr Stevens is on leave, but is going to attend to that today in an effort to try and reach agreement during the course of this week. So you've got that document in hand before we get to any of the highways evidence.
Okay, thank you very much. That'd be appreciated, and pass on my thanks for him doing that whilst he's on leave. And can I have an update on the agreed conditions, please?
Conditions, again, without sort of reciting what happened when, there have been draft conditions going backwards and forwards. If you just give me one moment, we responded to that was the highways conditions, wasn't it?
So the council had been making conditions last week. We had a response probably
okay.
Highways yesterday.
Right, you probably heard that, but I'll just repeat it for the sake of anyone who's all interested in this.
Yeah.
So the planning conditions, if I can use that terminology to distinguish them from the highways conditions, the planning conditions are well in hand. The council have got our comments on a draft, etc., etc., and I think we're not far off by the sounds of it vis-a-vis the planning conditions. The highways conditions we received, I'm not trying to make a point of this, but we received relatively recently, as in yesterday I think it was, and we've responded to those yesterday evening. So I don't know whether Mr Stevens' leave is going to be ruined even more, but But that's where we are with the highways conditions.
Okay, thank you very much.
Correct. And what I'm conscious that Mr. Stevens is not at work, not supposed to be at work this week. So what I've done, sir, in light of the fact that highways conditions came from the County Council yesterday, the appellant responded swiftly, I think, yesterday. I've asked for my clients, the council, to get onto the County Council's legal officer, who perhaps is involved in the Section 106 debate, to attend to the conditions as well during the course of this week in an effort to get an agreed schedule.
Okay, excellent. Thank you.
Thank you.
So it is in hand.
Yeah. And I think, not to raise your expectations too much, I think on the planning condition side, we almost certainly will have an agreed list or very little in dispute. On the highway side, certainly from what I saw last evening, unless there's a significant change of position from the County Highway Authority, I strongly suspect that although a few of them will end up in some sort of agreed form, there's one in particular which most certainly won't be agreed, which, to cut a long story short, is a long list of various improvements here, there and somewhere else, and but we'll see what the formal response is to that.
Okay.
What I'll do, sir, is when we get to the conditions session, which I think is due for week 3 in the current draft timetable, we'll make sure that whether it be Mr. Stevens or another County Council representative is here to feed into that debate.
Okay, thank you very much. Yep. And whilst I appreciate the condition session is still a way away yet, it would be helpful to have a copy of that well in advance of that, so that I can feed some comments back to you myself. So
that'd be very helpful.
Yep.
So, well, it sounds as if we certainly should be able to get the planning conditions to you in a agreed or very little not agreed version during the course of this week, I would have thought.
Absolutely.
Highways would just have to wait and see what the County Council...
one of the advantages of having a relatively light timetable this week is that it allows the parties to progress some of those other matters.
Indeed. Yeah. Excellent. Thank you. Good. And moving on to the planning obligation then, I saw some correspondence yesterday on that. Would you just like to explain that so that everyone in the room can understand what the proposal is on that?
Okay, well, there are two distinct things in relation to the Section 106. One is, what's it going to say? And a draft is circulating in relation to that, and I'll just double check, is that with us or with the council?
It's with the council.
Okay, thank you. You might have heard that, sir. So the current draft is back with the council, and the parties are seeking to meet later this week to hopefully, make progress vis-a-vis the covenants in the Section 106 planning obligation. So that's where we are with that. Again, I don't know your practice, but whether, like you've mentioned in relation to conditions, whether you have a practice of issuing comments in advance of the 106 session.
I would prefer to be able to do that so that we can speed things along.
Thank you. So it sounds to me, though, as if you almost certainly won't be seeing an advanced version of the 106 until sometime in week 2, by the sounds of it. So that's where we are with that. So that's one distinct point. The other distinct point is way above my pay grade. I'm going to get someone who actually understands the point to explain it. That's Mr. Lloyd, who's sitting behind me, and that's in relation to counterparts. Have you received an email, sir, as if via your case officer? Would you like Mr. Lloyd just to explain the point to you?
If he could, yes.
Yeah, can you see him all right?
I can see Mr. Lloyd fine.
So you might introduce yourself and just...
Indeed, and if you could speak as loudly as possible, because I'm conscious you don't have a microphone.
I hope it's not. I'll leave it there and see what happens.
Thank you, sir. I'm Richard Lloyd. I'm a partner at Evershed Sutherland, who's the solicitors instructed by the appellants. In relation to the Section 106 agreement, usually the practice is that there is one engrossment that's signed by all parties. So in this case, the number of owners comes to around 30 people who have to sign the agreement, as well as the council and the appellants. Given where we are, which I think is we are going to be negotiating it this week and possibly into next week, in line of the fact that we're looking to end the inquiry possibly at the end of the third week, it may be difficult to get one document circulated amongst 30 people, including one party, I think, is in the Isle of Man. So we are requesting that it is slightly exceptional circumstances with a number of owners that we might be able to do it by counterpart instead, where we will have 2 or 3 identical engrossments, so that everybody signs at least one engrossment. So we have it do it that way. We're just wondering if that would be acceptable for you, sir.
Okay, a couple of questions on that. If some time was allowed after the inquiry for a single document to be submitted, how long would be needed in order to? I appreciate 30 owners is quite quite burdensome.
So I think I'm looking across at my client there, because they're very kindly going to do the practicalities. But I would thought if we had an extra week, would you think that would be?
Why don't we ask for a couple then?
Yeah.
All right, a couple of weeks would potentially cover it. I would prefer to see a single document, if that can be done within a couple of weeks. I understand 30 owners is even then that's going to be potentially challenging. If it does transpire that you can't do it within 2 weeks, or you don't think that you're going to be able to do it within 2 weeks, if you were to use counterparts, then would you have a clause within each one to identify that is
yes,
right?
I think what we would do then is send probably the one with the most signatures to you, and then we would send you certified copies of the execution pages of the others.
Right. Okay.
But I think I'm hoping that if we were to have, say, 2 weeks after the end of the third week, that we would be able to get everybody to sign one document.
Okay. Good.
We'll double check on that timescale, sir, and we'll come back to you. But if we need a bit more time, we're asked. But
Much appreciated.
yeah.
Okay.
You, sir.
Right. Thank you. Mr. Ponter, did you have any comments on that at all?
Just 1 or 2 observations. I think that we had the draft planning obligation on the 10th of August, and I know that a solicitor in the council has been going through its terms and has made considerable progress in doing so. The county council is also a party to the current draft of the document, and there are covenants within it relating to transport matters. And so we are trying to liaise with the county council as well. I know a meeting is taking place today between the borough council and county council legal representatives dealing with the planning obligation, to understand the county council's position as far as those obligations are concerned. And then, as I think Mr. Lloyd has said, it's envisaged that the borough council solicitor with charge of this issue will meet Mr. Lloyd in the course of this week, hopefully with some helpful input from the county council having been provided. As for process, so the borough council is quite happy for the counterpart route to be taken, if that's satisfactory to you. I'm sure that if an extended period were required for execution of a single document, that would not be an issue for the borough council.
Okay, thank you very much. If you can get back to me on that,
I will.
then,
So I'll take
in due
instructions
course.
and
Okay.
get back to you ASAP.
Okay, thank you very much. Right, all documents should have been submitted. Any new documents for the inquiry? Mr. Katkowski?
No, sir, nothing new.
Fabulous. It's good to hear.
Makes a change. I just had one question, though, sir, if I may, and that is the air quality roundtable session. You've very helpfully, if I might say, indicated the particular point you're interested in. Would we have an agenda from you, sir, or is that the point that our 2 air quality people should prepare themselves?
That is really the point. Of course, questions may lead from that, but that is really just the single point that I'm hoping to understand.
So it's implicated because, as is known from the evidence which you very helpfully indicated you've read. The County Highway Authority witness, Mr. Stevens, and the appellant's witness, Mr. Axon, are some distance apart on what traffic numbers, if you like, should be fed into the various models, etc., etc. And as the statement of common ground on air quality records, that potentially, you've seen our evidence, we don't think it probably does, but potentially has a bearing on the air quality issue. We're just seeing whether we can find a way through this, and I'll come back to you on that. But as I understand it, the sole point you're interested in inverted commas in particular is how the traffic numbers wash through the
yes,
process
because according to the statement of common ground, it seems to suggest that it will have those figures would have no impact on the concluding.
That's right,
mitigation.
and that's because, as I understand it, so I know more about this now than I ever wanted to know about the subject, to be honest, but as I understand it, there's a formula which is applied in relation to air quality issues. So you feed your traffic numbers into this, you feed in some understanding of mitigation, and out comes a sort of, I think it's called a damage cost, but out of this comes money which is paid into a fund which the council, doubtless the council's EHO will explain this obviously later on this week, which the council then use to finance, to fund air quality mitigation measures more generally. And so what we're just trying to work out for ourselves is whether there's any way in which we can short circuit this debate. But I'll come back to you in relation to that. So anyway, it's helpful to have the point that you're particularly interested in mind. So.
Yes, I've noted, sir, is your query is why the dispute over traffic data is relevant to the air quality issue, in very broad terms.
Well, it is, but it's really also to do with the conclusion and the fact that the statement of common ground seems to suggest that the conclusion is reached and agreed regardless of the data that is input into it, and that's really the point that I'm trying to understand. Do we need to talk about traffic data feeding into an air quality model if the conclusion is ultimately the same?
Well, I think the bottom line conclusion would be the same, but it washes through into how much money is paid into the fund. That's the point.
The bottom line conclusion is that in air quality terms, the scheme is not unacceptable, subject to the right level of mitigation, which turns on, in part, how much traffic you plug into it. That's what I understand the position to be. So, but we've got a round table discussion, and so I've no doubt those who know more about it than and I will be able to tell you.
Okay, good. Right. Thank you very much. Mr. Ponter, did you have any new documents to submit?
Only the little email that went about the building height issue,
right.
Which I'm not sure if it's made it onto the website yet, but it will end up there.
Thank you. Right, okay, I do have all of the proofs and rebuttals with me in hard copy to refer to, but the appendices and core documents I will access electronically. If you are wanting to refer me to any particular page, it would be helpful to refer it to me electronically if you can. If not, we will muddle through. I understand that no documents can be left in the room overnight, so we have to take stuff out. Is that correct?
It's not in the main room.
Not
There might be a room that we can.
Yeah, there's rooms for the appellant's side there that are lockable and
Oh, okay. So we'll be able to leave documents in our respective rooms. Okay, excellent.
I'm not lugging this box back. So if anyone wants to pinch it, they're welcome to.
There'll be somebody to do that for you, Mr. Kate.
If only. If only.
Okay, thank you. Right. Okay, turning to the main considerations then, the Council provided 11 reasons for refusal on each decision notice, which in my case management conference summary were distilled down to 6 main issues. The Council has subsequently withdrawn its objection relating to sports facilities. And mindful of that and of the Secretary of State's reason for recovery, in my view, the main considerations are whether or not the proposals are suitable in light of local and national policies for housing, with particular regard to master planning, design code, phasing, infrastructure delivery and implementation programme. And just for confirmation, this hasn't changed from the CMC summary. Whether or not the proposed development would have a severe adverse impact on the local highway network. The effect of the proposed improvements to the B-Lane Bridge on the safety of pedestrians and cyclists. Whether or not the proposal makes adequate provision for highways improvements with particular regard to the Cross-Borough Link Road and the B-Lane Bridge. And whether or not sufficient information has been supplied to demonstrate how impacts on air quality will be mitigated, and if not, whether this matter can be addressed by planning conditions or obligations. A number of other matters have been raised by interested parties and in particularly from Keep B Lane Rural, KBLR, and these will need to be addressed by the appellants in their evidence. In particular, KBLR have provided some very detailed submissions regarding highways matters, flood risk, city deal and education. And the appellants' written responses to those matters are rather thin at the moment. So some advance warning that I'd be looking for you to respond to that in greater detail, perhaps in evidence in chief.
Right.
No need to respond to that
No,
now unless you have a particular point.
I do,
but
sir.
something for you to think about.
I do,
Yep.
sir. Thank you. So the 4 were, I think there were 4: highways, flood risk,
City deal
city deal,
and education.
and education.
I think if I can just confirm with that they were
Yeah.
the main areas of
Yeah.
interest for you.
Well,
Yes.
certainly, so on flood risk, we've produced what I would regard as an extremely detailed response to Keep B Lane Rural Group's commentary on flood risk matters.
It may well be that I just haven't seen it as yet. I have, for example, on flood risk, Mr. Allsbury's comments in his proof.
Oh, I see.
I'm just wondering
okay.
whether it goes further than that.
Oh, yes, indeed. So, sir, in Mr. Allsbury's appendix number 4, and I actually insisted that each and every point raised by the group was responded to in terms by our flood risk experts. And
Good.
That's
Right.
appendix
That's
4.
what I haven't seen then. Yes.
Thank
So,
you.
Okay.
In relation to the city deal aspects, you will have obviously the comments in Mr. Allsbury's proof, but also at appendix 1 to his proof there's a letter from Homes England.
Okay.
We're not making it any part of our case that the city deal arrangements are a material planning consideration for you to take into account in your report in our favour, so to speak. So, but that's all explained. The education position is set out in Mr. Allsbury's proof. I would double check whether we need anything more on that. And certainly in relation to highways, there's a section of Mr. Axon's proof, but I'll double check to see whether more is
Okay.
required in relation to that. But
Yep.
certainly in relation to flood risk and the city deal, I have, unless when you've checked those documents you come back and say that's still insufficient, I don't have any intention of supplementing that material because I'm not sure what else we could say, to be honest. But
Yep.
I'll leave those in your hands, so to speak, to double check, sir. But I will then take the highways and education points and just have a discussion about those. So.
Okay, thank you very much. Good. Right, I will have a look at those myself over the next couple of days and let
Thank
you
you,
know
sir.
before the end of the week.
Thank you.
Right, whether or not any of those other matters that have been raised are to be considered as main issues will really depend on how the evidence emerges, and ultimately that will be a matter for the Secretary of State. Any other comments on the main considerations? No.
No, thanks.
Okay, thank you. One final procedural matter from me. I've never met Mr. Katkowski before, but I'm aware that we are sharing the same hotel. So in the interests of transparency and fairness, yes, if Mr. Katkowski and I do meet in the hotel, whilst I'll be polite, I won't be talking to him.
Ditto, sir. But don't take it personally. Sir.
Exactly. Yes, yeah. Mr. Ponter, any objections to those arrangements?
None at all.
Okay, thank
I'm
you
sorry
very
I
much.
can't join you.
You wouldn't say that if you saw the hotel. Can we object?
Sorry?
Can we object
What would your objections be?
that there may be improper communications between the two of you?
Okay, so what can we do to assuage that fear for you?
You actually accommodated in a different hotel. You
Sorry?
can always move hotels, presumably.
I potentially could do. Whether I would be able to move this quickly, so that I wasn't staying there tonight, probably not.
Yeah, I understand. It's just a concern we have. So.
Okay, so an assurance from me that I have no intention of speaking to Mr. Katkowski, and an assurance from Mr. Katkowski that he will do likewise wouldn't satisfy you in that respect.
I think we appreciate that. You bringing that point to light anyway, it's appreciated.
Okay, so you're not satisfied with that?
I think we are just concerned.
Okay, right. What I will do then, I will have a think on that and see what. Well, I will get back to you on that point as to what can be done on that matter.
Thank you, sir.
If it helps at all, sir, I mean, just for the gentleman from, I'm not sure whether it's Mr. Eastman or Mr. Bow, who's
Both of us.
both of you, jolly good, for the two gentlemen in question. So at the hotel, we, the appellant's team, have our own separate meeting room, so we're not actually holding any meetings in a public space, if you like, so there's no chance at all of you coming across, so to speak, discussing the case. And it's not at all unusual for a situation to arise where the inspector is staying in the same hotel as one, rather than on this occasion it's us, on another occasion it might have been the local authorities barrister or their team, and one just uses common sense, and frankly the system works in such a way that we all behave ourselves and apply the higher standards. As much as I'd like to chat to you at the hotel about all sorts of things, obviously one wouldn't do that, because one needs to ensure that everyone's content that justice is being done properly and fairly. So, but anyway, if that's insufficient reassurance, then if you can get back to us as whether you can move, if because of the systems that you have through planning inspection, if it's difficult for you to move, then there are obviously quite a few more of us than there are of you, but if we have to ship out, we'll have to ship out. But
I will have a think on it and get back to everyone on that. I think one of the difficulties is that there are a limited number of hotels within Leyland that we can stay in, and of course there is a risk that if I move to another hotel, I could be in the same hotel as Mr. Ponter.
Unless you're staying at my house.
Oh, okay, right. Well, that's good to know.
And I'm not extending an invitation.
Thank you. I'm pleased to hear that. Thank you. Right. Okay. I will come back to everyone on that point. At this point in time, I'm not sure whether I'm saying that I will move. I'm just saying that I will consider it, and I will get back to you and let you know what my intentions are. Any other procedural matters?
No, thanks.
No.
we've
Okay.
got our fair share, so no other procedural matters. So.
Okay, thank you. Right, well, that concludes my opening remarks. In which case, we'll move to openings. Mr. Kukowski, thank you.
Thank you very much indeed. So if you just bear with me for one moment. So I've got written copies, but presumably our closing and my learned friends will go onto the website. So presumably this will need to be emailed to somebody.
Yes.
I don't suppose it's the case officer, so is the council's responsible for the website?
Janice Crook, whose email I'm sure you've got.
Just
Yeah.
perhaps you could send me over to Craig.
Yes.
Yeah. Right, we'll sort this.
Lovely. Thank you very much.
Thank you very much. Couple, please.
There are a few copies here. So these are our brief opening submissions. So first of all, by way of introduction, as the council's planning witness explains, that's Mr. Wood, Pickerings Farm is the largest housing allocation in the South Ribble local plan. It's a strategically important location and allocation, being central to the achievement of the strategy in the Central Lancashire core strategy in the local plan. And I give the references from Mr. Wood's proof where he says all of those things. The appeal sites, somewhat imaginatively you might think, labelled A and B, together amount to some 67%, so about 2/3 of the allocated area. Local plan policy D1 indicates 1,350 homes as the estimated number of dwellings for the allocation, and the appeal allocations, A being up to 920 homes and B being up to 180 homes, propose in total up to 1,100 homes, and that's some 82% of that indicative number, so about 2/3 of the site and 82% of the indicative number of homes. Unsurprisingly, there is no, nor could there be, an in-principle objection to the appeal proposals. The council refused both applications for identical reasons. There are 11 of them, some overlap. One of them, reason for refusal number 9, concerning sporting provision, has been resolved, and the appellants and the council have agreed upon a way forward to resolve another, that's number 8, concerning air quality. That leaves 9 reasons for refusal, which you've grouped into your main issues 1 to 4, and that's right. So yes, they're still your main issues 1 to 4, just keeping up with your what you've said this morning. So the first main issue, that's master planning, design code, phasing, infrastructure delivery and implementation programme. The first main issue draws together the council's reasons for refusal 5 and 6. These reasons for refusal contend the appeal proposals are contrary to local plan policy C1, which states planning permission will only be granted for the development of the Pickerings Farm site subject to the submission of an agreed master plan for the comprehensive development of the site. The master plan must include the wider area of the Pickerings Farm site, which includes the safeguarded land, which extends to Coot Lane, as shown on the policies map, and make provision for a range of land uses to include residential, employment, commercial uses, green infrastructure and community facilities. There's to be a phasing and infrastructure delivery schedule, and then an agreed programme of implementation in accordance with the master plan and agreed design code. And so the key part of reason for refusal number 5 is that the master plan has not been formally agreed by the council, and the version submitted with the 2 applications doesn't meet the policy requirements. And reason for refusal 6 is that the submitted documentation provides insufficient detail on how the site will be delivered, and no detailed phasing plan has been submitted, and no programme of implementation has been agreed. Now, taking those points step by step, policy C1 does not require a single planning application to be brought forward for the land which it requires to be included in the master plan, nor could it, as the policy requires, and the word in the policy is must, the policy requires the master plan to, and I quote, include the safeguarded land which extends to Coot Lane. The safeguarded land in question is location S2 in local plan policy G3, and that provides that within the borough land remains safeguarded and not designated for any specific purpose within the plan period, and then it lists the locations of which are safeguarded land, so to speak, as one of those. Existing uses, the policy tells us, will for the most part remain undisturbed during the plan period or until the plan is reviewed. Planning permission will not be granted for development which would prejudice potential longer term comprehensive development of the land. In other words, One cannot make a planning application now, for example, for housing development on the safeguarded land. Given that policy C1 doesn't require a single planning application to be brought forward, even for the allocated land, it seems obvious that the underlying purpose of requiring a master plan is to ensure that as and when planning applications are made for the development of parts of the allocated site, which after all is in multiple ownerships, I mean you've heard this morning even our bit is in 30 ownerships, there is an overall strategy for the wider area which individual application should be consistent with, so that individual parts facilitate rather than inhibit or preclude bringing forward the greater whole. That is precisely what the master plan which accompanies the two appeal applications does. Reason for refusal number 5 seeks to make something of the fact that the master plan has not been agreed by the council. This one assumes there's a reference to the passage in policy C1 which speaks of an agreed master plan. The policy doesn't dictate that the master plan has to be agreed separate from a planning application, nor that it can only be agreed by the council. Put shortly, if you, sir, and the Secretary of State conclude in the appeal decision the submitted master plan is suitable, then that would satisfy the policy. Reason for refusal number 5 contends that the submitted master plan doesn't meet the policy requirements. Now that can only be a reference back to because the policy referred to is policy C1. That's the policy cited at the beginning of the reason for refusal. So what then are the requirements of policy C1, and does the submitted master plan meet them? Well, the policy requires the master plan to include the allocated and safeguarded land. Ours does. The policy requires the master plan to make provision for a range of land uses. Ours does. Including the allocated and the safeguarded land and making provision for a range of land uses is what the policy means when it says the master plan is to be for the comprehensive development of the site. And that's it. There are no other policy requirements for the master plan set out in policy C1. Reason for refusal number 6 draws on those parts of policy C1 that require a phasing and infrastructure delivery schedule and an agreed programme of implementation. To the extent the reason for refusal makes the point about the programme not having been agreed, as in agreed by the council, the points made earlier on apply just as much here. The appellants have submitted a schedule and programme to meet these requirements. It's found at Mr Alsbury's Appendix 2. It's dated July of this year. It was submitted in draft for discussion with the council. We'd welcome any constructive comments the council wishes to make, but in any event, as paragraph 1.3 of the document explains, the appellants would expect there to be an obligation attached to each of the planning permissions which requires a fuller delivery strategy to be submitted and approved at an appropriate point before the development commences. The submitted schedule and programme does what the policy requires. It is a phasing and infrastructure delivery schedule, and it is a programme of implementation. The first main issue, that's your main issue, so it also refers to the design code. Now the last few words of policy C1 refer to a design code. We've submitted a design code. None of the reasons for refusal criticise it. The second main issue is whether or not the proposed development would have a severe adverse impact on the local highway network. This main issue combines reasons for refusal 1 and 2, both of which contend that it has not been demonstrated that the proposed development would not have a severe adverse impact on the local highway network. The double negative is telling. The phraseology is drawn from paragraph 111 of the National Planning Policy Framework, which mandates that development should only be refused on highways grounds if the residual cumulative impact on the road network would be severe. The framework doesn't define what it means by severe, and so it's used in its ordinary meaning rather than as a term of art. The Oxford English Dictionary tells us severe means very great. Underpinning these reasons for refusal is the County Council's view that the appellant's transport assessment isn't, to put it bluntly, fit for purpose. A year on from the submission of the applications, the County Council's witness, Mr Stevens, has put forward his own traffic assessment as part of his proof of evidence, which again, to put it bluntly, we do not regard as fit for purpose. There's little point summarising why the appellants and the County Council's analyses are so far apart. This would be explored in evidence given and tested during the inquiry. What seems more pertinent is one shouldn't be distracted by all this from the simple point that applying the appellant's analysis, the proposed development would not give rise to severe impacts on the road network, But even were one to apply the County Council's alternative analysis, it doesn't demonstrate the proposed development would cause severe impacts on the road network either. And I think in my readings I've emphasised the proposed development, and if I had my time again I would have underlined or italicised those words, so the emphasis is on the proposed development. Third main issue, the effect of the proposed improvements to the B-Lane Bridge on the safety of pedestrians and cyclists. The third main issue draws from part of reason for refusal number 3. Paragraph 111 of the framework sets, and I quote it, an unacceptable impact on highway safety as the threshold of refusal. Policy 7 of the neighbourhood plan includes the B-Lane Bridge as part of the Penwortham cycle and walking route, which is to be safeguarded for a dedicated circular route for cyclists and walkers. In other words, as a matter of planning policy, more use is planned to be made of the bridge by cyclists and walkers. The appeal proposals would similarly lead to more use of the bridge by cyclists and walkers. There would be some, not much, additional vehicular traffic on the bridge too. The appellant's witness, Mr. Axon, considers the existing shared surface, in inverted commas, arrangement would be acceptable in terms of the safety of pedestrians and cyclists. However, he has produced an option for the segregation of the carriageway from the bridge parapets and pedestrians, similar to the existing arrangement at the nearby Coot Lane Railway Bridge, which an independent safety risk assessment has rated low risk and thus acceptable in safety terms. As Mr. Axon explains, this is simply one way, that's to say not the only way, of improving the existing situation. So I note you referred to your perambulations yesterday that you'd been across B Lane and Flag Lane Bridge. You didn't mention Coot Lane.
No, I haven't.
Bridge.
I'm just noting that down
100%
now. Yes.
one that you really do need to, as it crosses the railway. You've got photographs of it, but seeing it in real life is
Absolutely, yep.
far more
Thank you.
compelling, if you like. Fourth main issue, whether or not the proposal makes adequate provision for highways improvements, with particular regard to the Crossborough Link Road and the B Lane Bridge. This main issue is a synthesis of points raised in reasons for refusal 3, 4, 7 and 10, and perhaps there's a tad of number 11 there as well. In relation to the B Lane Bridge, the improvements already referred to would be adequate for all users of the bridge. Turning to the Crossborough Link Road, the CBLR, this part of the case made against the appeal proposals by the council seems, at least to us, to combine a misunderstanding of what the local plan requires on the one hand and what we propose on the other. The Crossborough Link Road, the CBLR, has its genesis and ideas generated so long ago it was the same decade as the referendum to join the EU. Some of us in this room, probably not you, sir, would be old enough to remember that. That's my first vote, actually, was in that first referendum, way back in the 1970s. Beginning with the local plan, policy A2 protects land from physical development for the delivery of the CBLR, part of which is shown diagrammatically on the policies map as running through the Pickerings farm allocation. And that's all that is required by policy in the local plan, just to safeguard the route. Paragraph 4.21 of the supporting text in the plan explains this section will be provided through developer contributions. As a matter of law, and we cite the Court of Appeal case in the footnotes, as a matter of law, supporting text cannot impose requirements on developments. Neither the policy nor the supporting text, not that it could anyway, requires the developer of part of the allocated site, even a large part of it as per our appeal application A, to build or pay for the whole of the stretch of the CBLR as it passes through the allocated site, let alone a new bridge across the West Coast Main Line, which is one of the options. The other is improving the existing B Lane Bridge, which is mentioned in the supporting text in the local plan. In terms of the appeal applications, the master plan safeguards a route for the CBLR as it would cross the allocated site. The appeal schemes would deliver, as in build, those parts of the road, some 1.08 kilometres, just over a kilometre, as it crosses through appeal site A. It doesn't impinge on B at all, at a cost to the appellants of over £5 million. This would amount to some 89% of the link road as it crosses the larger allocated site, leaving in the order of 113 metres to be built on the in-between land. In anyone's book, This should amount to a substantial contribution to the delivery of the link road. The appeal schemes would also pay an estimated £7.6 million in infrastructure levy, which could, of course, to some or other extent, be spent on delivering the rest of the link road, including, for example, paying for or contributing towards a new bridge over the railway. It is a travesty to suggest the appellants aren't doing their bit towards delivering the link road. They are. Nor is there any basis for saying that it's necessary in the sense meant by SIL Regulation 122, you'll be aware of the tests, for the entire length, or indeed any part of it, as the footnote says, of the link road as it crosses the allocated site to be delivered in order for the appeal proposals not to cause a severe impact on the road network. In overall conclusion, the determination which would be in accordance with the development plan when read as a whole would be to allow both appeals. Material considerations do not indicate otherwise than this. Should the conclusion be reached contrary to our case that the appeal proposals do not accord with the development plan, then in those circumstances material considerations, and in particular the extensive public benefits which are discussed by Mr. Alsbury in his proof, would indicate otherwise, such that the appeal should be allowed nonetheless. The 30% affordable housing, that's to say up to 330 affordable homes, is a hugely worthwhile public benefit in its own right. Those are our opening submissions.
Thank you very much indeed.
Gosh, bang on 15 minutes. Wow.
Very good. Okay, thank you. Mr. Ponter.
Thanks, sir.
Thank you very much.
Perfect, thanks. Thank you so much. That's great. All right. Do not lose, Craig. Craig. Thank you.
So I start by setting out what these appeals concern. I don't read that out, given the introductory material we've been through during the course of the morning. And we know, as I say in paragraph 2 of my note, that the sites are located within the wider site benefiting from an allocation in the Council's development plan. I'll just give you the references within the core strategy for the identification of the strategic location south of Penwortham, and that's policy 1 of the core strategy. And I note at paragraph 3 that that document recalls that the strategic location comprises a broad area of search, and that the South Ribble site allocations plan will identify the extent of land to be brought forward. And that's precisely what it did and does. The Council's local plan identifies 3 major residential-led development sites. There are other major employment-led development sites we didn't concern ourselves with. And Pickerings Farm is the largest of those 3 sites and appears on the policies map at site EE. And then, as you've heard, there is safeguarded land to the south of the allocated site, and that's designated under policy G3. Again, as you know, the local plan anticipates the development of up to 1,350 dwellings from the 79-hectare allocated site. And I just record some of the supporting text to the relevant policy in paragraph 6.7 that I picked in particular, which states that the comprehensive development of this site is crucial due to its size and strategic importance, as well as to ensure delivery of essential infrastructure and local services. And that's reflected in policy C1 itself, that makes it clear that in order to benefit from the grant of consent, there must be an agreed master plan for the allocated site, extending, as you've heard, to cover the safeguarded land to the south. A phasing and infrastructure delivery schedule must be submitted, and I note in the footnote that that's to be secured through a legal agreement. That's paragraph 6.10 of the supporting text to policy C1. And then finally, an agreed programme of implementation that accords with the master plan, and an agreed design code must also be submitted. So I note there just an additional point. Where, for example, there is reference to an agreed master plan, clearly, in the first instance, that's for agreement with the local planning authority as decision maker on any planning application. Of course, where planning application has been refused and there is an appeal on, for example, the basis that there's no agreed master plan, the decision maker is someone else, in this instance the Secretary of State. If the Secretary of State agrees with the master plan that's been submitted and its sufficiency, then we agree, there's nothing between the parties to say that that part of the policy would be met. So it's agreement, amongst other things, with the decision maker. Decision maker now being the Secretary of State. Returning to text. The appeal schemes together comprise just over 52 hectares, and we've heard, unsurprisingly, from the appellant how significant a part of the allocation that is, but significant parcels of land outside of the red line boundaries for the appeal sites are interspersed across the allocated site. You'll see that from any of the red line plans before you. And it's understood that much of this land that falls outside of the appeal sites is in the hands of third parties. Now, just a bit of history. Following the adoption of the local plan, that was back in July of 2015, work commenced on producing a master plan for the allocated site in 2018. There'd been I note again an addendum, there'd been an earlier effort to produce some, I think probably the jargon is visioning material to support allocation of the site, but that then went onto a back burner and was restarted in 2018. And that culminated in the submission of a master plan to the Council by the appellants in August 2020. The Council wasn't satisfied with its adequacy and rejected it. Now, sir, in tandem with the preparation of that master plan, that was rejected in 2020, the appellants prepared and submitted 2 planning applications. One for outline consent for development of up to 1,100 dwellings, and another for a section of the Crossborough Link Road from Penwortham Way to the west of the allocated site to Bee Lane to the east of the allocated site. Those applications were withdrawn by the appellants, and that was in March 2021. The appellants have chosen to adopt a similar approach in respect of the appeal schemes. They've not made a further planning application for a section of the Crossborough Link Road across the allocated site, but they have pursued planning applications for the development of land under their control with the allocated site, whilst at the same time advancing a master plan. So they've gone in tandem again. We recognise that the master plan submitted in support of the appeal schemes has moved on from that rejected by the Council in September 20. However, it remains deficient in our view, and those deficiencies form part of the basis for our refusal of planning permission back in November 2021. The Council's refusal of consent, as we know, wasn't confined to concerns about the master plan, and we know that 11 reasons for refusal were advanced in respect to the appeal schemes. I note that one of those was the result of the statutory consultation with Sport England and was a concern about how additional demand for sporting provision would be met. That concern has now been addressed, and that element of the Council's reasons for refusal is no longer pursued. Others are, however, and I turn to highways impacts. Another of the statutory consultees, and that's the County Council in its role as local highway authority, was also concerned about the adequacy of information submitted in respect of the proposals, as indeed were National Highways. Those concerns have not been addressed to the satisfaction of the County Council, notwithstanding the provision by the appellants of further information on the subject of highways impacts during the course of these appeals. The local highway authority still considers the appellant's approach to the assessment of highways impact to be deficient, and in an effort to assist the inquiry, the local highway authority has undertaken its own assessment of impact of the schemes on the local highway network. There are important points of difference between the appellant's and local highway authorities' approach to assessment, and I don't go through them all, sir, but I note that they include the base traffic flows both now and in the future, trip generation and distribution, and the assessment of impact at individual junctions, as opposed to the appellant's approach of modelling likely changes in journey times across a limited number of defined routes. Those are some of the significant issues between the highways engineers at this inquiry. The local highway authority's approach demonstrates that at certain junctions on the local road network, the appeal schemes generate a level of impact that requires mitigation. Those requirements are not accepted by the appellants. Quite apart from the methodological differences between the appellants and the highway authority, there are, it appears, points of principle that appear to be in dispute. They are: what weight should be given to additional delays for drivers during peak hours? That appears to be a point of significant dispute between Mr. Axon and Mr. Stevens. And secondly, the likely success of measures advanced by the appellants in an effort to reduce the reliance of future residents on the private car. And we'll come back to both of those points. I note this in general terms at paragraph 18 of my note, relevant to those two general points of in principle dispute, that in respect of both of those points, and contrary to the appellant's repeated assertions, the local highway authority does not advocate what's been termed a predict and provide approach. Instead, in this case, as with all others, and in discharging its statutory duties, the local highway authority seeks to prioritise active travel